laws that Labor left for 9 years, that they choose to oppose this bill.
Calling Eugenie Sage.
Thank you, Mr Chair. Well, I think the speech by the previous speaker, as always, seeks to twist how the law operates slightly. And, Mr Speaker, that is partly because of this whole concept of adaptive management, which I'll get onto in a minute, because I think the number of supplementary order papers that are before the House on this part of the bill reflect unfinished business in the Select Committee, and a number of concerns that opposition parties raised there that have not been resolved. But before going on to those, I would like to, Mr Chair, record the Green Party's thanks to officials. There was a lot of debate in Select Committee, a lot of interchange with officials, and they dealt with that very professionally and have put a huge amount of work into the bill. So, Mr Chair, in terms of the SOPs that the Green Party is proposing, one of them, in my name, is around this whole issue of adaptive management, because the concept of adaptive management is one of suck it and see. And the previous speaker has referred to caution and the precautionary approach, and like Labor, and we support Moana Maki's SOP, caution is a very new term in the legislation, and it contributes to legal uncertainty, to opportunities for more litigation by using that rather than the more commonly understood precautionary approach. But if this cautious approach means that an activity is likely to be prohibited through regulations, or a marine consent application is likely to be refused by the EPA, then the Minister or the EPA must consider whether using the adaptive management approach would allow the activity to proceed. And that's meaning that it proceeds at a certain scale. There's some monitoring done to determine whether it can continue and be expanded. So, in our view, Mr Chair, both clauses 33A and 60A create quite major obstacles to the Minister prohibiting damaging activities and to the EPA declining consent to them. And as submitters such as Forest and Bird noted, it turns the precautionary approach on its head, because it fails to recognise that there are situations where a suck it and see approach through adaptive management is not appropriate, and that's where there's a risk of causing irreversible environmental harm. So the supplementary order paper number 90 in my name redefines adaptive management to exclude an activity that risks causing irreversible harm, such as affecting the population of a threatened species or destroying a biodiversity hotspot like a seamount. And it would delete this requirement in clause 33(4) that before prohibiting an activity, the decision maker first has to consider adaptive management. And the Green Party, Mr Chair, is concerned about the changes which the Government Order Paper 100 make to the definition of adaptive management, because that further expands the scope for using it. When we were considering Part 1 of the bill, and when we passed that relevant part of the SOP 100, we effectively deleted the bill's definition of adaptive management from the interpretation clause, which would have clearly allowed a marine consent to be revoked and the activity discontinued. Deleting that and then relying on clause 62A for the definition of adaptive management means that there's no clear ability for the EPA to revoke a marine consent to ensure that an activity is discontinued if it's found to have more than the impacts that the EPA expected. And, Mr Chair, the experience under the Resource Management Act is that when you review consent conditions, you can't cancel a consent. So the former interpretation and definition of adaptive management was quite critical to allowing the EPA to revoke a consent, and my concern is that that is now gone. And I think that is quite typical of the permissive approach to the government's oceans management through the EEZ regulations, which, as Moana Maki mentioned, came out after we'd reported back from Select Committee. And that's where that permissive approach is illustrated in the fact that seismic surveying is permitted, and that's despite there being the potential for quite significant impacts on marine mammals and fish. Because where you get these seismic surveys occurring, you get these big high-pressure air guns being towed behind a survey vessel. They produce pulses of high-energy sound, which is directed at the seabed, but it can spread horizontally for hundreds of kilometres, and that can be, Mr Chair?
Eugenie Sage.
That can have the effect on marine mammals that is quite disturbing, and for them it can be the equivalent to us having a 747 jet engine taking off. So, Mr Chair, we have a concern around adaptive management. One of the other issues of concern is that in clause 33, as Nikki Wagner pointed out, in terms of the list of matters which the EPA must consider when making regulations, is, and I quote, the importance of protecting rare and vulnerable ecosystems and the habitat of threatened species in clause 33(3)(d). Yet when the Minister is making regulations, and also in the parallel provision in clause 59, they can only consider an impact on a threatened species and their habitat if the Minister has previously declared that threatened species to be previously gazetted a species as threatened. And only 2 species have been gazetted by the Minister of Conservation as threatened species, the New Zealand sea lion and the Hector's dolphin. And, Mr Chair, our SOP sought to actually change that so that there was a reference to the New Zealand list, or New Zealand Threat Classification System list, and to the IUCN's red list of threatened species. That we didn't have a political process which the bill sets out, that the Minister of Conservation must declare a threatened or gazette a threatened species for it to be given status under clause 33. So that remains to be a concern. We are also concerned about the failure in this part of the bill to have any provision for spatial planning in the marine environment, because the government has tendered more than 40,000 square kilometres of offshore seabed for oil and gas exploration, yet we don't have any provision for deep water marine reserves and no legislation to do that. So there is no regime for creating these deep water marine reserves to balance the exploration that's occurring. And that's why Gareth Hughes' Supplementary Order Paper 102 is important, because it makes amendments which would provide for marine reserves in areas such as the Kermadec to be extended offshore. And some of the protection initiatives that we have at the moment, such as the benthic protection areas, are totally ineffectual, because we're already seeing applications for prospecting for phosphate in those areas, and there's no constraint on that. So, Mr Chair, we've got a number of changes. We support Labor's SOP 103, seeking to replace caution with the precautionary approach, and major concerns about adaptive management.
Call Reno Tarakardini.
Kia ora, Mr Chair. Pleased to